We're here to talk about the new legislation that our dear government has decided to put on us. So, us wonderful landlords. And this is just a caveat. I didn't write the legislation and I don't agree with most of it. Um, so don't shoot the messenger, please. Now, some landlords in England may already be non-compliant and they just don't even realize it. Um, because this government just makes laws up left, right, and centre. Now, some landlords in England may, and the dangerous part is because from the 1st of May, the rules around the tenancies, possessions, rent increases, and landlord compliance have fundamentally changed. And I'm finding that many of my landlords still think that they're operating under the old system. And I'll give you several examples throughout that will, hopefully help you realize if you're doing the same. So they're not operating under the old system. Everybody must realize it. And unfortunately, the penalties for getting things wrong are no longer just small admin issues. We're talking about delays in possessions, civil penalties, rent repayment orders, and council enforcement action. Now, in some cases, tenants are financially rewarded by pursuing claims against landlords. Now, it was always like that, but I think it's now more enhanced. And for those of you that don't know me, and I see there are lots of strangers in the rooms that I haven't been to my previous webinars, I'm Bridget and I've worked in property industry for nearly 30 years. And honestly, I've never seen this level of confusion in the private rented sector. My role within our organisation is legislation and compliance, and I oversee the lettings and sales department at Gateway Property Hub. We are estate agents in South London, Croydon, South London. So welcome all the Croydon people. And my role is to make sure we are doing things legally. Now, the Renters' Rights Act, which came in on 1 May, is the biggest change I've ever seen in all my time of being in lettings. The last big change was in 1988-89 when the assured short-hold tenancy came in. And, that was a big renewal of the lettings industry. And I don't know if all this new stuff is going to be a renewal. Perhaps 10 years down the line, we'll look back and think, oh, don't know what we were stressing up about. So I do these quarterly webinars for landlords and investors like you to keep you up to speed with the latest developments in the lettings and sales world. So that's why I'm here today talking to you about this. So you self-managing landlords, we need to listen carefully. Every day at the moment, I'm hearing somebody told me this. I saw this online. My tenant says that. Facebook, TikTok, everything says something different. Now, landlords like you might be struggling to work out what is actually changed and what is still coming and what needs to be done right now. Does this sound familiar? Yeah, probably does. You're definitely not alone because at the end of the day, most landlords are not legal professionals. Well, some of you might be. Um, and because at the end of the day, most landlords, we're just trying to manage, you're just trying to manage your property portfolio, deal with repairs, try keep the tenants happy, pay your mortgage, and somehow you're still expected to keep up with the legislation that seems to change every 5 minutes. So hopefully most of you are not bad landlords. The fact that you are here means that actually you care and that you're probably very good landlords. But the new legislation that landlords are now operating under has become far less forgiving of mistakes. So tonight we're going to just simplify it. Well, hopefully I will be able to simplify it, and together you've got time to ask questions on the chat all the way, and then we'll stop halfway through and we'll answer some questions. So we're going to simplify this together, and we're going to go through what's already changed, what still matters before the end of May, what risks landlords should actually focus on, and the things that are causing panic online, and sometimes you know, the stuff that's causing panic online is sometimes not even the stuff that we have to focus on. So please stay till the end because the final section tonight is probably the most important practical part of the whole webinar. I'll be covering what landlords should already have done, what can still be corrected, and the realistic options you now have if you want to stay compliant and protect yourself from going forward. Slide. So today's agenda, we're going to sort of split it in two phases. So we are going to have a timeline of the main phases, penalties and risks, the death of the AST. I didn't draw the gravestone this time, unfortunately. On my previous webinars, I had like a big dramatic gravestone with AST on it. And the start of a tenancy. Oh, I do have it. Start of a tenancy, what we need to look at. Rent increases, how that's changed. Then we'll have a short Q&A in the middle, so you can put questions in the chat now. We'll answer that. Ending a tenancy after that. And at the end of May, the documents that we need to have ready and what being non-compliant means at that stage. And then we'll have live Q&A again. And then I'll tell you about our next webinar. And throughout, I will refer back to what we're going to be discussing at the next webinar and what you can do if you've got concerns. So this is the Renters' Rights Act phases. But before we get into the timeline and the changes themselves, let's quickly see who we've actually got in the room today. Just make this a bit smaller. So I think we've got a lovely mix of people in the room. I know we've got investors, we've got landlords, we've got quite a few of our fully managed landlords in the room as well. Our regulars that come to all our webinars, which I know that are self-managing landlords. And we've got people in there that are actively looking to invest, buy, or are thinking of selling. And I'll and expertise, the poll, self-managing landlords, um, so it's average. That's a good mix of people with portfolios and ones who have not started yet. So just to let you know, the knowledge you need is the same for one property or for 20 properties. And why using a letting agent actually makes sense, because sometimes it's nice to put a distance between you and the tenant and it allows you to get on with the rest of your life. And that's why a lot of you are using letting agents to a degree, like a mixture, you know, just finding a tenant, at least they're doing all the tick boxes. So obviously tonight we can only speak generally because every landlord situation is different. Some of you may have older tenancies, some may be fully managed, some may be self-managed, some inherited properties with paperwork totally missing. I know a few of the recent people that I've helped have, you know, unfortunately had bereavements, and then when they try and fix their dad's missing paperwork, they find huge holes. So if later you feel you need to speak to me quickly and me quickly looking at your situation, your specific situation, then I'll be offering short 15 3-minute landlord review calls. And remember, I see there's a comment there of somebody renting to family. So just be careful. All these things apply whether you rent to a family or not. Now, oh, I think I've gone too far. Okay. So these are the changes. So the changes are, most landlords are underestimating how quickly these changes are arriving and how little time we have to adjust properly. So the first phase arrived in December 2025 and it sort of snuck in on us. It changed on the 27th of December, and that is when the local authorities gained more enforcement powers, including access to properties and penalties for non-compliance. So it is, it is quite scary what has happened already. They were given stronger enforcement powers and the rent repayment orders. So they've started expanding significantly. And I'll come back to that in a moment because financially this council phase is actually the biggest risk to I let somebody in and I lose my place. The biggest risk to landlords is actually the in councils. And then phase two, obviously, when they announced all these phases, they announced these phases. Oh, yes, the council will do it. I don't think the council even knew they were ready for this. Then phase two is the 1st of May 2026. Now that's gone and passed. And from the 1st of May, the tenancies of assured short-hold tenancies effective. Amazingly enough, the 1st of May is everything that landlords had to do, nothing the government had to do. Section 21 disappeared. It's too late now. It's gone forever. Tenancy rules changed. Rent increase rules changed. Discrimination rules changed. Rental bidding was banned. So there's a whole lot of stuff that's changed. And that was from the 1st of May. Now, phase three and that's in late 2026. Ugh. Phase three is the introduction of private rental sector database requiring landlord and property registration. It will also bring in the property ombudsman, the landlord property ombudsman. I don't know, the people in my industry are not too convinced that this will happen in 2026. But sometimes we are unfortunately surprised by the efficiency of our own government when we don't want them to be too efficient. So we will see what happens. So what we will not be covering tonight, which is still very important, is we won't go into making tax digital, which is coming in June. It's already started, but in June you need to submit your first digital tax return. EPC proposals, I'm not going to go into that. We'll have a new webinar for that specifically. And then selective licensing. Now in Croydon, I know they're bringing in selective licensing in September. So we will have that webinar on 12 August. We will have about licensing in general and what it means for people having properties in a licensed area. Okay, now let's talk about the part that makes this real. Enforcement, because historically there have absolutely been rogue landlords getting away with things for years. Councils are now increasing their enforcement activity significantly, and the financial penalties are becoming a lot more serious. Yes, you have to earn over 50,000, but you know what? It adds up. Because I had I'm not going to go into making tax digital. I get actually quite agitated when I talk about making tax digital. But yes, you have to earn jointly more than 50,000. That is your fixed job and your property and or whatever earnings you have before that applies to you. And honestly, most landlords are not bad landlords. They're just simply busy people trying to keep up with rapidly changing rules. The problem is this new system is becoming a lot less forgiving than it was before. Now let's talk about the part that makes all of this real: enforcement. Because if we're all honest, historically, enforcement, I mean, the rogue landlords got away with murder. Not physically murder, but a lot of rogue landlords were under the radar. And the frustrating part is that good landlords were paying the price, or now paying the price for the behavior of those bad landlords. So the historically weak enforcement, is now coming back to bite us in the back. So what I'm already seeing, and locally, is councils are gearing up. They are gearing up because they are now in charge of that enforcement, and their enforcement teams are growing. The local authorities are recruiting. And civil penalties is what the council can give you. They can give you civil penalties. They are becoming more and more significant revenue streams for them. And the civil penalties sort of start at 7,000. Previously, it was 5,000 before the 1st of May. Now, after the 1st of May, it's 7,000. And then repeat offences are 40,000. Now, you know, you can get a range of penalties for a range of sins, like, and one of them is what we're going to be discussing at the end of the webinar, is that letter that we have to give to our tenants. And we've got a strict deadline for this. So, and then the scary bit that I heard recently is that if you have I don't know, I think these inspectors must get paid per job, these council inspectors, because so if a guy sits across the fence in another borough and he's getting a bit bored because his borough is quite well behaved, he can pop across the border into Croydon borough and just go and invade a bad area and then do a few cases to up his claim rate. So that is really quite scary. So, and then also because the councils can financially benefit from this enforcement, believe me, the enforcement tends to improve very, very quickly, very quickly. So this is where landlords really need to start paying attention to the numbers. Many civil penalties are now moving about 7,000, 40,000, and rent repayment orders are another risk. So I wrote there rent repayment orders. Up to 24 months rent is reclaimable. Now that goes through the tribunals. So the council can't give a rent repayment order, but they can ask for it if they have a tenant on housing benefit or one of their social tenants that lives in a property. So this is not a slap on the wrist anymore. Imagine you getting a £40,000 fine for something that the council said you should have done, plus then the tenant goes to the tribunal and asks them for a 24-month rent repayment order because they have suffered really greatly because you didn't have a license or you didn't put it up on the wall or, you know, something really significant. So it's not just a slap on the wrist anymore. What worries me personally is that some of these risks are no longer just the obvious big things. It's also little administrative mistakes, like the paperwork that's due at the end of May. If you don't do that, it's £7,000. And literally, you know, that is an administrative mistake. Missing paperwork, compliance gaps, documentation failures, or perhaps a landlord just not realizing that things might have changed. And just want to see where I am. Yep, I'm still in the same place as everybody else, so that's good. So the councils now have much stronger powers around inspections and information requests. So what they can do now is they can just pop into a letting agent's office and say, we want those papers now for this property. So if a tenant reports an issue, or even if a tenant doesn't report an issue and the council inspector feels like doing a bit of a raid, he can pop into a letting agent or office or a landlord's home where he works from home, or a tenant's home to go say, oh, by the way, I'm just here to come check. And you are obliged to give all your documentation on the spot. They can take away computers. So let's hope that they stay human and not overreach their powers. So your maintenance history, you know, I mean, if you're self-managing landlords, probably your maintenance history probably lives across WhatsApp, random emails, 2 old phones and a notebook in a kitchen drawer. Now that may be the moment to improve the system a little bit. And honestly, most landlords are not bad landlords. It's just they're busy, simply busy people trying to manage their tenants, their repairs, their mortgages, rising costs, their own lives, their rapidly changing legislation. And so the message here is do not panic. The message is landlords now need to operate more professionally than ever before. And one of the biggest changes of all is what actually happened to fixed term tenancies from the 1st of May. So let's talk about that next. Just need to move to the next slide. Yep. Just double checking. Follow the new rules or get fined. I think, but we already spoke about that. So this is just like a pretty picture. So unlimited fines for violation. I'll have to look up what the definition of a violation is, because there's civil penalties, there's rent repayment orders, and it seems like there's now violations as well. Warrantless inspections, we've mentioned that, and it covers all landlords and HMOs, every private rental property where you do not live. If you own a property and you do not live in it, and other people live in it, you are the landlord. Unless you rent it out on short term. This thing is now in my way. I thought we were getting... So selective licensing, don't get caught out. This is one of the things that belongs to the council thing as well. They implement all these selective licensing. I'm not going to go too deeply in it. I know Croydon is going to get selective licensing, and it is, we fought tooth and nail against it. I can remember, I think I met Louis at one of those meetings. We were unsuccessful, unfortunately, and selective licensing covers every property in a designated area. So watch out that your property does not suddenly fall within a designated area, because tenants can claim up to 24 months via a rent repayment order for an unlicensed property. Was it Angela Rayner that didn't have a license on her property, and actually she was fired from her job? So that is similar to this. So this is the death of the AST. Let me just check where I am. Yep, the death of the AST. So what's changed? So fixed term tenancies have been abolished. All tenancies from the 1st of May are periodic, and there's no more automatic end dates. And what this means is that you've got less control over your tenancy length. You can only rely on the tenancy ending on a... You can't rely on a tenancy ending on a set date, and tenants have a lot more flexibility. So let's go through that a little bit. So the practical changes happened on the 1st of May. So the fixed term tenancies as we knew it, because that's an AST, assured short hold tenancy, they are gone. And this is the biggest structural change that we've seen in years. Many landlords still just don't fully understand what losing the AST means. So every assured short hold tenancy from now on, now the old tenancies have suddenly become a assured periodic tenancy. And that bit still catches landlords out. Now, you could have signed a 6-month tenancy on the 1st of April or 12-month tenancy, but on the 1st of May, it became a periodic tenancy. So that tenant can give 2 months notice from the 1st of May and can leave at the end of June. So much for your 6 months fixed. So if you recently signed a 12-month tenancy, that tenant can just give you 2 months notice and leave. You could have signed a 6-month tenancy, you could have signed a 12-month tenancy, but from the 1st of May, those tenancies are automatically converted. You do not need to do anything. There's no need, you don't need to put a new tenancy agreement in place. No action is required. It simply automatically changes. Mentally, the landlords and the tenants, I must say, are still in the mode of the old system, because we get people coming to viewings and then they say, oh, I'd like a 2-year tenancy. Sorry, mate, can't do a 2-year tenancy. And then, is the landlord going to serve me Section 21 as soon as I move in? No, he can't serve you Section 21 anymore. So The 2 months notice that the tenants must give you is aligned with the tenancy due date. So that means that if they're moving in on the 1st and they give you notice on the 2nd of that month, they must wait until the 1st, and then the 2 month will start counting, so they can leave at the end of month 3. Now that means that a landlord can have 4 tenants a year. So 1st of January, 1st of, oh, I'm going to do my maths, 1st of April, etc., etc. But tenants still want stability, so it's not all doom and gloom. It's reality versus panic. I mean, I know we're starting to panic and think, oh, what if this tenant wants to move, a new tenant wants to move out every 3 months, but they want still stability. Now, the Cornwall example is that there you've got holiday lets. Now in Croydon, not many people have got holiday lets, sorry. This area just doesn't lend itself to holiday lets. I know it's sunny in Croydon, but that's as far as it goes. We've got a lot of parks. We do have parks. And then, so what a lot of landlords are doing, they're actually removing the furniture out of their furnished accommodation so that people can't use it as a holiday let, because it's sometimes cheaper to get a 1 month, pay 3 months and stay in it for a month and then not be there. But then also, tenants must give 2 months notice, but they must do it. They can do it by text, by email. Anything is valid from now onwards. So gone are the days where they have to give it in writing as per the tenancy agreement. They can they can do it via WhatsApp, text, email, send you a letter. They cannot do it over the phone. They cannot do it over the phone. And the best thing is for landlords to document everything. Now, there are joint tenancy risks. In other words, that if you've got a husband and wife and they split up and the one of them says, I'm moving out, I'm ending my tenancy, then that ends the tenancy for the whole household. You can sign a new tenancy with the new tenant. You can't just assign, like on the old tenancy, you can't just say, oh, change of tenant, or I haven't heard that that's possible. It should be possible, but there's a specific regulation that says it comes to an end. You can always renegotiate with the remaining tenants. And the only route for eviction is now Section 8. And we'll go through that in a little bit. And then we'll go into rent increases in a minute. So the practical scenarios are tenants can leave with shorter note. They need to give longer notice, but they can leave quicker. So they don't have to wait for 12 months to, which is really difficult for landlords to plan long term, because you think, okay, I've got a new tenant, he's good, he's going to stay for 12 months. You just don't know. And then the existing tenancies, please do not use the existing tenancies, the old tenancies anymore. Those are they don't exist anymore. They are not valid anymore. So there's a big impact on possession. So that is Section 21 is gone. And you can only regain possession on certain grounds. And I'll go through that at the sort of a bit just after the Q&A. Then greater importance. So I think, the relationship between tenants is really important. You don't want to have one tenant that leaves, because that's going to cause the whole tenancy to collapse. They must still give 2 months notice. But that's, in theory. I don't know if they give notice and then they don't move out, what happens. We will just have to test these cases as they come along. We want stable tenants, and hopefully we get them by doing very good reference checking. But documentation is absolutely critical. Now, remember in the olden days, before 1st of May, we used to worry about deposits, a right to rent, how to rent booklet, electrical certificates. Those things are still need to be done. Don't forget about those. Okay, so The positive side is that you can still negotiate a brand new agreement with whoever remains if one partner moves out. And then it means that you can revisit the rent. So you can increase the rent in that position. But only if they can afford it. So we'll now go deeper into what it means to what is it? Death of AST. No, sorry, my a bit confusing. So this is the death of the AST. I think we discussed everything there. It was just a double slide. And this just means that landlords need to evolve and adjust. Rent reviews are not a fist fight. They are a spreadsheet, a conversation, and some deep research. Rent reviews yet. The start of the tenancy. Okay, so we're going to do a start of the tenancy, and we're explaining all the things that we're not allowed to do anymore. Like deposits and all that. That is old-fashioned. Well, the new rules are the practical side of setting up a tenancy under the new rules, because honestly, this is where a lot of landlords and tenants are our agents are going to need to retrain themselves slightly. For some of the things that people have casually said in a property for years are now becoming genuine compliance risks, like the beginning of the tenancy. Now it starts at advertising. There's a prohibited blanket bans on. So in the olden days, we used to have the Equality Act. We still have race, sex, disability, religion, sexual orientation, and other prohibited characteristics. And now they've added to that, you can't say no to children and you can't say no to benefits. The pets are not discrimination. They're not part of the Equality Acts, but they do come in here as well. Now we've got extended, strengthened protections around tenants with children. So be careful of those people who phone up and say, oh, I like your property. It's me and my 3 children. And be careful of saying, I'm sorry, no children, because then they could report you and you could be coming up for discrimination. You can't say no DSS or no housing benefit. Affordability is still allowed. So it's really important to be consistent in applicant assessment. The mortgage clauses is remember the days when we said, oh, the mortgage doesn't allow us to accept people on benefits. Mortgages won't be allowed to do that anymore. And actually, the law is now overriding the mortgages. The same with buildings, where they said, no housing benefit or no students. That cannot be done anymore. So consistent assessment is really important. Rental bidding is banned. Now what rental bidding? So if you have a tenant at a property and he says, oh, I really like this property and I'll offer you £10 over the asking rent, and then you tell another tenant, oh, so-and-so has given me £10 over. If you offer more, that is rental bidding. You cannot allow rental bidding. So if you advertise a property at a price, that is it. You're not allowed to go higher. You can go lower. You can't ask for rent for pets anymore. We used to ask for extra. We had to revisit all our adverts and we had to ask, you remove that all. So how can you get around not getting kids? So we've got like a 1-bedroom flat or studio flat. And how do we get around not allowing people with children there? Well, if it's a single, on our advert, we said a maximum of two persons, whether that's a mom and her child. I suppose we don't have much control over it, but at least it's 2 people. And the excuse that we can use is that 2 people is the limit that we want to allow for that property. Otherwise, it'll be overcrowding. So pet requests, we need to Pet requests, we cannot unreasonably deny pets, but if there's a good reason, like the building doesn't allow it, or animal cruelty, that is a really good excuse for who's going to be with that dog the whole day if the people are at work the whole day. So documentation and consistency is critical. We can still assess people on their affordability, their rental history. So if you get somebody that applies to you and he hasn't got a very, a stable job, then ask him for his rental history. You ask for their references. You ask for their financial stability and judge them on their suitability for the property. Everyone must be assessed fairly and consistently. And honestly, most landlords are not trying to discriminate against anyone. It's just that they're trying to avoid rent arrears and protect their property. If there's one, oh, I clicked on something. Clemmy, I think somebody is wanting to come in and I clicked on it by accident. Oh, I'm still on there. No, evolve, start of the tenancy. Sorry. So I was talking here. Prohibited blanket bans. So I forgot to go forward. So we cannot allow our advertising to say no DSS and no kids. But we can say no on the grounds of affordability. And we can say no to overcrowding, but we must just keep a records of why not. Because I've had in the past where a tenant phoned and wanted to apply, but we'd already let it. And then she complained to shelter that we discriminated against her because she was on housing benefit. We were luckily able to prove to them that we didn't say no to her because she was on housing benefit. We said no to her because the property was genuinely let. And why would we do another viewing on a property which is already let? So the end of the fixed terms, this slide should have been somewhere else. And before the fixed terms, at set end dates, the landlord could reclaim his property at the end. Section 21 was used and rent review clauses were in the agreement. And now, after the 1st of May, all tenancies are periodic. Landlords must have a legal ground to evict, and Section 21 is no longer valid. And rent increases must go via the Section 13 notice. Now, tenants have the right to request a pet. They must do so in writing. And it says in the tenancy agreement, even in the new one, it says there that they must apply in writing, and the landlord cannot refuse without a good reason. And this is really important. So if you've got a tenant who says no, they don't have a pet, and then they move in, and day one they apply for the pet because they already got a pet. I know they are in breach of their contract by lying to you that they have a pet, but what you're going to do? Go to court about. It's pick your battles. So only tenants have this right. Landlords can still say no to pets in an advertisement. I don't know how true that is, and I don't want to test it. So I'm just not saying anything about pets in advertisements. And the landlord, if the landlord gets a request for a pet from a tenant in writing, then he must respond in 28 days. You can't just ignore it and hope it goes away. Because it's not going to go away. Because the law says 28 days you need. Now we're going to get to the rent increases. I've been waiting for this. I was trying to get to it, and I wasn't getting to it. Renting with pets. Yep, rent increases. Okay, great. So the rent increases. Now this has changed a bit. So previously you could say, "Hi, Mr. Tenant. I think I want to increase your rent." And that was fine. And if the tenant said yes, that's fine. You can't just pick up the phone to Mr. Tenant anymore. You need to put it in writing. You can't just put an email. You must have a specific Section 13, and they've updated the Section 13s that used to be in existence. And the things that there are several rules for the raising the rent. So first of all, you need to make sure what is the market rent. Because if you raise the rent, if you give the tenant a rent increase and it's above the market rent, and he can take you to the tribunal. He can take you to a tribunal anyway. And if the tribunal finds that you've raised it too high and it's above the market rent, then they will say you must reduce it, and it will just delay the rent increase, because actually the tenants can now go to the tribunal, and the tribunal will not implement the new rent until they've made a decision, and that could take 6 months because they're going to be so busy. Now, the notice period for landlords has changed. It used to be 1 month. So I know when you called the tenant and said, from next Wednesday that the rent is increased, but officially you should have given them 1 month. Now it's officially 2 months, and it must be in line with the rent due date. So if they are paying the rent on the 1st and you wake up to the fact, oh my gosh, I wanted to increase the rent for this tenant on the 5th, you then have to give 2 months notice from the 1st of the following month. So you've lost 2 months and 3/4. There's a limit on the rent increase frequency, because no, you're not allowed to put a clause in your tenancy agreement anymore. So it means that you need to do it in line with the market rent, not with the RPI or inflation, or how much the tenant earned or doesn't earn. It must be in line with the market rent, and you need to keep proof of your research that you've done, because if it gets contested, you want to be able to say, Mr. Judge, these are the rents that were going in the next door neighbor, this one, that one, that one. So it's a lot of work, and keep all those records. So tenants, challenges and tribunals. Oh, the limits on the rent increase frequency. Now, every 12 months. So if a tenancy started 1st of January 2025, you cannot increase the rent until the 1st of January 2026. And you need to give 2 months notice. So you need to sort of start getting your ducks in a row before the 1st of November 2026. Their tenants can challenge you. They can take you to tribunal. If they are undergoing hardship, they can also go to the tribunal and say, I'm undergoing hardship, and then they can delay it for 6 months, even if your rent increase was totally reasonable. So just avoid disputes over rent reviews, and have a conversation with your tenants. We always suggest we have a conversation with our tenants, and we say, this is, your rent has not increased for the last 5 years. You are still on £1,000. Neighbours are paying 1,500. We are suggesting a rent increase to 1,300. Get him to agree it in writing, and then issue the Section 13. He can still go to the tribunal, but hopefully he'll be in a better mood, and he won't say, oh, I'm going to just take my landlord to court. It's not a court, it's a tribunal. So step 1, once per year only. Step 2, use only Section 13 notices, and it needs to be filled in a specific way. It's a prescribed information. Certain things need to be in there. It needs to be served. So it's not just I'll just fill it in any old way. And 2 months written notice, and it's strictly, and it needs to be served and all that. So do not leave it to 12 o'clock that night before to serve it. So the problem here with the tribunals is the tenants can challenge the Section 13 at the tribunal. The tribunal can make decisions, and that could take up to 6 months. And then the increase only starts from the decision date, not backdated like previously. So in practice, annual reviews may become 18-month cycles due to delays. Now, this is something that that landlords will have to sort of build in to their strategy, because you think, okay, because it's going to take me 18 months, I'm going to increase it higher than the market rent. And then seeing it's going to take 6 months, but that's not going to work either because it's going to make the tenant cross. He's going to go to tribunal. Tribunal's going to chase it down anyway. So I don't know. You're not allowed to increase your rent above the market rent, and how you prove that market rent is up to you. So I'm now gonna, before we move into ending a tenancy, possession, and Section 8, I want to quickly just check that in with everyone, because we've covered quite a lot already. So after hearing tonight's webinar so far, oh, mostly confident, sound, and we are still finding our feet with those tiny little things, and we'll get to those things in the next section when we say ending a tenancy, because it's in the fine print. Or and that is that I'm going to go to Q&A, and I'm going to go to Q&A. So just remember, all these questions, what we presented here is quite generic. So if you've got specific questions that you want to ask, book a call with me. Clemmy will put the link in the chat box again. Oh, you asked me about what types of offences. Okay, yeah, I did a bit of research on that. Let me just see. Where was it? I sent it. No, I can't remember now the things. I just read it up because it's like a long list of offences for the civil penalties. So the rules have changed so quickly. Let me. So we got a lot of questions. So can I register my son's property on the database? We're not going to go over the database at the moment. That is our next phase, and we'll have a webinar in time for the database things. I'm not going to go over making tax digital either. If you're non-compliant in one aspect in the past and now corrected it, let me just see here. And now corrected it, would tenants still be able to raise a complaint? It depends what it is. Certain things are unforgivable, like if you never registered a deposit, it's too late. If you never have if you never had a gas certificate when the tenancy started, it's too late. If you didn't serve them on the how to rent booklet, it's too late. But you can make good, and then hopefully the tenant will not remember what you didn't do. And you'll only be liable from before you made good. So like, for instance, if you pay back a deposit. But we're not going to go into the normal compliance stuff. If this thing that is this letter that we have to serve on our tenants before the end of May, that is going to be unforgivable. So if you haven't done it by the end of May, there's no making good at £7,000. You don't have to apply for a license if you're not in a license area, and we're going to go over that in our next webinar. What offences do you get for civil penalties? I did put that exact thing in my Google earlier on. The civil penalties are the things that the council fines you for, like not getting a license, not having a valid tenancy, not putting the deposit in place. No, I might be wrong on that one. Having damp and mold, not fixing things in time. It's what the council would give you serve you with a notice. The rent repayment order, it comes more from when a tenant claims it back, and then it goes to court or tribunal. Does this letter apply only to new tenancies? No, it applies only to old tenancies. So I'll go through that in a minute. Do I need to know who lives in my house if I use an agent or a rent guarantee agreement? That's a good question. If he works with the immigration office, does renters' rights? You must do renters' rights on everything, but we're not talking about normal compliance in this webinar. We're only doing the renters' rights The renters, sorry, I misunderstood that question. If he works with immigration office, does renters' rights? I think you're getting confused with the right to rent. Even if he works for immigration office, you must do a right to rent check. But that is normal compliance. This is not the Renters' Rights Act compliance. So how can you prove you gave them the paperwork by hand? That is just, like normal stuff. You take a photo, him putting it, but he must have received it. And I know it's really difficult, but the only way you can do it is either recorded post or proof of posting or by delivery by hand, or if he replies to your email or something like that. My agency said they would deliver the letter before the 31st. No, you don't have to worry. If your agent said that they would do it, then you don't have to worry. But I would ask them, please provide me with proof. So, because then you will be the one that has to prove that this was done. How can you, okay, agency said, I'm sending an email and getting the tenants to reply. Yes, that's good enough. As long as they reply, because a lot of tenants just don't reply, and especially if they're not very friendly. If fully managed by estate agents, do they deal with the paperwork end of May? Yes, they're obliged to. If your property is fully managed, your letting agent is obliged to serve that paperwork on the tenant. If it's a rent collector only, I would ask, because that is not fully managed. Who damaged the what penalties are there for tenants who damage the property and sublet to foreigners and refuse to provide identification? I think that's more a breach of contract. Really difficult. Just, you should have used Section 21 to get them out. I would report them to immigration and say, if you've got a full record of asking for that information, and just report them to Home Affairs. My agency says the paperwork, can I trust this is okay? Ask them for proof. Yeah. Ask them for proof. You mean, okay, exactly the various bits they need, gas, electric. Yeah, the normal compliance still is still needs to be done. So, you can ask for a proof of the gas certificate, proof of electric. If I rent my house out before 1 September, do I need to get a license from Croydon? We don't know exactly when the licensing scheme is coming out. It could be the end of September. And then if you rent it out the 1st of September, there's no licensing scheme yet. You need to look on the website of your council and check if your property falls in a licensed area. And you have to have, if your council has a licensing scheme, you need to adhere to those licensing things in their requirements before you can rent out a property. I know this, I'm not even going to go into this licensing thing because I get so cross. The Ombudsman is coming in end of the year. Don't know if it will, but hopefully not. But we'll see what the government does and how long does it take them. Bridget, please talk about tenants and pets. I have allergies. Does this count against someone against getting cats and dogs? No, you don't live in the property. I don't know who the question was from, but if you lived in the property and you go abroad and you're renting out your property for a year, and then you're coming back and you're using the grounds that you will be moving back into the property, I suppose you can say no to pets. If your property is a buy-to-let, you've got a buy-to-let mortgage, never lived in it, nobody's going to care whether you have allergies or not. If your property is in a business name, a business doesn't have allergies. A business cannot live in the property, so it doesn't matter if you, the director of the company, has allergies. The company's never going to live in that property. and a list of the documentation. I've got a checklist that I can send you. I will have a look. I will send you a list of all the documents that you need. And I'm not going to talk about selective licensing now. What is a license for maximum fortune? Okay, let's not talk about licensing now. I know there are a lot of people from other areas which have got licensing, like Nottingham has got licensing, and you are limited to a certain amount of people, and you just have to speak to them or look on their thing, on their regulations. So if I want to sell a rented property, am I right in thinking that I would be put the notice in writing, giving 4 months notice? Yes, you're right, and we'll get to that in a minute. So how do you go about finding the market rent? Well, that is why agents are agents, because we know how to establish the market rent. Okay, where is it? So obviously tonight I can only answer in general terms. So if you want me to quickly look at your tenancy setup, your compliance position, your paperwork, or where you may be exposed under the new rules, then book a call with me. It's 15 minutes. It's free. It's an informal chat. It's just on the phone. And then if you need more help, we can establish that there. Also, if you are not au fait with what's it? What do you call these things? QR codes. If you're not au fait with QR codes, and you can't click on the link, you can also just type into the chat, you want a review or you want a call, and I'll call you tomorrow or the day after. Okay, so that is do some techie stuff. Claim me background. So I actually, this one is now just like an evolve thing, but we just have to learn to live with the new regulations. It's otherwise we're gonna, die, die like these dinosaurs along the side of the hill, and only the ones that learn to adapt. And I mean, I get the most horrendous requests from landlords sometimes. Oh, I don't want, this color, and I don't want that pet, and I don't want kids, and I don't want, um, and unfortunately, we cannot deal with people that have requests like that. So ending a tenancy is becoming more process driven, more evidence based, and far less forgiving. So the changes to possession processes. So if your tenant moved in on the 1st of January and you want to sell the property, you cannot get him out without giving 4 months notice at the end of the first 12 months. So he needs to be able to live there in peace and quiet for at least 12 months. So that, the Section 21, you decided you wanted to sell, you served a Section 21 if the tenant wasn't in a fixed period, and you could ask the tenant to leave for no reason, nothing to do with whether you like the tenant or whether he's a good tenant or not. Now, there's increased reliance on valid possession grounds. So there is like if you want to move back into the property, you need to give 4 months notice before the 12 months, or you need to give 4 months notice anytime, but you cannot do so until month 8. And more, the documentation and evidence matter more than ever, because there's a new ground on antisocial behavior, which is one of the few things that are good. And but still, they need to basically have a police record. So if you don't have a copy of that police record to present to the judge, then how are you going to prove that your tenant is antisocial? So how a simple mistakes can delay possession for months. So if your tenant, say for instance you wanted to sell, and you serve that notice 1 day too early, then that's an invalid notice. Or you put the wrong Section 8 ground on there, then that's an invalid notice. If you are a limited company and you want to move back into the property, you cannot use that ground for moving back into a property, because a landlord with a with a limited company, the limited company cannot live in the property. It looks like we're running out of time, yes, very quickly. So I'm going to have to rush through this. So valid grounds that the landlords must use are basically moving back into it, selling. And if you say that you are selling, you cannot, and you evict the tenant on those grounds, you cannot relet it for 12 months. So don't think that, oh, I'm just going to lie, I'm going to put it on the market, I'm going to sell, and then as soon as the tenant's moved out, I'm going to just relet it. There's a £7,000 fine that the council can give you. And remember, AI is our friend, but AI is our enemy as well, because you might have a lazy council employee that says, oh, I'm not going to do my work today. I'm not going to plow through 3 million for sales and see if that tenanted property was actually for sale. Because there's evidence, they can go on Rightmove and say, there was this property for sale. It'll pop up. If you are selling it privately, if there's any evidence of anything, you trying to sell and then going back on the market, so you can sell, just don't give your tenant notice that you want to sell. So you can sell with a tenant in. You can sell with you can say to the tenant, look, I'm planning on selling. Is it all right if I put the property on the market? We'll try and find a landlord to buy the property. And then the tenant says, oh, I want to look for another property. If he leaves out of his own, then that's fine. Then you haven't served notice, and then you can do whatever you want. But if you have given him notice because you want to sell, then that's a problem. Now, obviously, rent arrears, you can still evict people for rent arrears, but you'll need to have evidence. And they'll need to be 3 months in arrears, not 2 months anymore. And you can't take them to court 2 weeks after you've served them notice. You'll have to wait 4 weeks. So it's 4 months before you can even apply to the court. So make sure you've got rent guarantee insurance. So landlords who stay organised and follow the process properly will still be able to manage their properties effectively. Ending a tenancy, valid grounds only, documentation and evidence. Just see. Follow the process, correct notice, correct timing, correct service. Mistakes is delays. It's the same as what it is now. And communication matters. Expect delays, because I think the courts are going to be so overwhelmed and tenants are more likely to challenge it. So be prepared. Joint tenancies and reletting restriction, I spoke about that. So if one tenant gives notice and ends the tenancy for all joint tenants, yeah, okay. So say, for instance, one tenant moved out and you gave the new tenant, the remaining tenant, a new tenancy. Then unfortunately you have to wait 12 months before you can move back into it. So if you've got an existing tenancy, do not renew it unless you have to. You can renegotiate a fresh contract with remaining tenants, but that'll mean it's a new contract, and it means that you have to, abide by the new rules. So if you've got an old tenancy and you haven't renewed the tenancy, an old tenant and he's been there 13 years and you haven't renewed the tenancy, it's been on rolling for years, you've increased the rent in different ways, you didn't give him a new tenancy, you can give him 4 months notice today to sell. It's not a problem. And again, if your situation is unusual and you're not sure where you stand, don't panic. We can usually identify this type of thing quite quickly in one of our short landlord review calls. Non-compliance. We had a question about this, didn't we? So documents that landlords must update, we're going to get to this now. Okay, so what must be done before? Now, so The documents landlords must update before the end of this month. Now, a few of you have already mentioned it. And we all have to, if you don't have a contract, you need to create a written statement. So if you've got a lodger agreement instead of a proper tenancy agreement, you need to give them a written statement. And the written statement, I'll get to that. There's also a government tenancy information sheet. So if you've got an existing tenancy, you need to serve them the government tenancy information sheet. It's not really serving, you need to give it to them, but they also say you need to prove that they've received it, which then means that you should have served it on them. So you can't just send a link. You can't just send an email and hope they received it. Might have gone to the wrong email. You preferably want an answer back. You want something signed that they've read it. And, you know, for letting agents, we've got huge amounts of policy and procedures. And for not doing the written pay statement, if you don't have an agreement, or the government tenancy information sheet, there's a £7,000 fine, and it is not. So this is the Renters' Rights Act information sheet. If you have a, so if you have a tenancy, you need this Renters' Rights Act information sheet. And this is what it looks like. And it tells the tenant exactly what they can do and what they can't do. So if your landlord serves you notice seeking possession, then this applies. Change the name of assured short-hold tenancies. Your tenancy agreement might call your tenancy an assured short-hold tenancy, but this becomes an automatic periodic tenancy. Changes to the fixed terms, increasing the rent. Tenants need to know how that works. If your landlord wants to end your tenancy, the tenant gets told exactly what the landlord is allowed to do and not. If you, that's now the tenant, wants to end their tenancy, they need to do that by 2 months. So if their tenancy originally said 1 month, tough luck. This is now 2 months. You, as a landlord, are still fully in your right. If a tenant comes to you and say, Mr. Tenant, I've been a tenant here for you for, Mr. Landlord, I've been a tenant for 13 years. We've had an agreement that said I needed to give 1 month notice. I want to give 1 month notice because I didn't factor this in. You are totally within your rights to say, yes, sure, you know, it's fine. But if a tenant but if you want to, you can insist on 2 months. Keeping a pet, that's covered in there. And if you're a student, that's covered in there. So this thing must be sent as a PDF to the tenant, either by post. You must have proof that the tenant got it and that they read it. I don't know. How are you going to prove that? But we're doing it all belts and braces. So we're serving it on them as if it's a notice, a proper notice, so that we know. So this is an example of a written statement. So if you don't have a tenancy agreement, like I think one of the people said here that they have family, make sure you have a written statement. Don't just assume that because it's a family that you don't need it. You need your gas certificate. You don't want your family to die of gas poisoning. You need electrical certificate. You don't want your family to die of electrical shocks. It is a landlord's duty if it's your property, and even if your family lives in it, if your daughter lives in it, if your uncle lives in it, you are the owner of that property and you are responsible. So this is an example of a written statement. I got this from the NRLA. I've just taken all the little bits out that they said. So it needs the landlord name, tenant name, property address, the start date of the tenancy. Now, if this, I don't really know if this is now that it needs to be, or if at the beginning of when they moved in. I think it's probably fine if you put in the beginning when they moved in, what type of tenancy it is, the rent amount, if it's per week, per month, the rent due date, when they must pay it, the notice period. Oh, I minimum. So, I mean, I don't know why that says that, because the law says two months. So why? The deposit amount and where it's registered. Remember, that's an undoable sin. If bills are included, rent increase provision, security of tenure, signature, signature. So it must be signed, signed. You don't have a written statement unless it is being signed. So what's still to come? Oh, I thought, oh. So the database and the ombudsman are coming at the end of the year. The decent home standards are coming at the in, and Arwab's law are coming in about, was it 2030, and EPC is also 2030. Making tax digital is end of June this year, but it only applies to certain. From next year, everybody's on making tax digital unless you earn below a certain amount. So once again, book a chat to discuss your, are you buying, selling? You don't know what document you need to serve, finding gaps in your paperwork. What is your portfolio plan? Rent positioning, sense check. If you don't know what your rent should be, just book a call and we'll work it out. And then tenanted sales options. So if you are wanting to sell, there are different strategies available. And then please put more questions in the chat. Clemmy, do we have more? Let me just open there. Now I need to scroll through 100. No, Fiona, we do not manage your property, so we will not be sending your tenant a renter's reform document. So it's only fully managed tenants that the letting agent is obliged to send the documentation. And I wanted to, I'm going to scroll through the questions. The rent arrears has accrued over 14 months as tenants reduce the monthly payment with discount. Yes. If it's equivalent to 3 months rent arrears, over 14 months. No, it needs to be more than 3 months. So if it's £10, £10, £10, £10, it's not going to add up to 3 months. What if you want to move the tenant out so you can do works like an extension? Yes, there is a clause in one of the grounds, the Section 8 grounds. There is a clause that if you want to do, but it doesn't mean just ripping a few kitchen cupboards out and putting a new kitchen cupboard in. That's not an extension. If you get planning permission and you're going to take out, load-bearing walls and taking the roof off, and you need to get building control involved and stuff like that, you have to have the paperwork because you will need to prove who what you're doing, and then so my tenant has made 3 requests: fixing carpet, new fridge, a new mattress. How promptly do I need to do these? I've done the carpets. Well, if the fridge is still working and they want a new fridge just because they don't like the look of it, then I suppose it's fine to just say, look, I will do it in a few months' time. But if the fridge is making their food go off, then I would say it is quite essential, if they allow access, because we've got tenants that complain about their fridges not working properly, and then we want to have access, and they say, oh, I'm at work now, I can't do this. I wanted to say something before we go. So you've seen the QR code, and so I'm just gonna say, okay, the new webinar, the next webinar is the 12th of August. We're gonna be focusing on licensing and what is coming in force at the end of 2026. And we'll do a little bit of a roundup about the new laws that came in on the 1st of May. And then see how we all got along and what practical problems we got. We'll dive into real world early lessons since the 1st of May. And because 12th of August is Elephant Day, I know, I looked it up. And so we're going to put our big foot on this legislation and get and trample it to death so that we are in charge of our future. I'm just trying to see a once again is the private rented sector has changed permanently. You know, the old way of managing tenancies, paperwork, and compliance is simply not good enough anymore. You need to have filing systems, you need to have a full record of every time a tenant phones, every time you reply, recorded calls, you know, the whole hog. We always advise that you, obviously, we always advise that you use a managing agent for your properties because our systems do that. And then don't underestimate AI and say, oh, the, the council won't notice if I do this behind the scenes. They do. They've got AI coming in. They've got all sorts of they've got all sorts of tricks up their sleeve. So despite all the noise online, despite all the panic, property is still a long-term business, Jocelyn. People still need homes. Good landlords are still needed. Good landlords who run their properties professionally will continue to do well. And then if tonight has made you realize that you might need another pair of eyes on your own situation, please don't ignore that feeling. The booking link for the short landlord review sessions are in the chat. And I mean, last time after our webinar on the 12th of February, I had loads of lovely chats, and I know a few of them are waiting for their tenants to move out before they take the next step forward. Because a lot of my landlords luckily followed my advice when I say serve Section 21 now, and they did. And one of our landlords said, when I said, get rent guarantee insurance, she did. And then luckily, otherwise she would have lost 10 months worth of rent. So these sessions are, you know, these webinars and our chats are really there to help landlords get clarity where they stand, what should be prioritized, and whether there are any risks that could be corrected sooner rather than later. And then those landlords who adapt early will be the landlords thriving 5 years from now, or the rules may have changed, but good landlords are still incredibly valuable. Thank you for joining tonight. I just want to, how many? Yes, only how many? 10 minutes overdue. Clemmy, I just want to ask if you found tonight useful. I would generally appreciate a quick Google review afterwards because it helps other landlords locally to find us, and it cuts through all the misinformation that's out there online at the moment. I was a bit super nervous tonight, and my tongue is like a little bit sore. So apologize if I slurred over my words and spoke unclearly, and hope to rectify that next time we speak. And good night, and thank you for attending.